Hello, I am Judge Todd Taylor. I'm a district court judge in the 19th Judicial District in Weld County. I'm going to talk to you about the defense obligation to provide disclosures in a criminal trial. What are those obligations? Because compelling discovery from a defendant implicates the constitutional privilege against self-incrimination and a defendant's right to effective assistance of counsel, the answer to this question requires a trial court to carefully balance the prosecution's right to learn about the nature of the defense with the defendant's important constitutional rights. Part 2 of Rule 16 governs the defendant's obligations to provide disclosures. But Rule 16 also makes clear that it must be applied with the constitutional limitations in mind. Rule 16 establishes 4 categories for which a defendant has an obligation to provide information to the prosecution. The first category is the defendant's obligation to cooperate with non-testimonial identification procedures. These procedures are set out in more detail in Criminal Procedural Rule 41.1. The United States Supreme Court has held that the privilege against self-incrimination does not prevent requiring a defendant to submit to fingerprinting, photographs or measurements, or from having to write or speak for identification purposes, including appearing in court. A defendant can be required to stand, to assume a stance, to walk, or to make a particular gesture. A defendant can also be required to submit to blood testing for chemical analysis, including DNA analysis. Rule 41.1 includes a list of specific items that a defendant can be required to provide, including palm prints, footprints, blood and urine specimens, saliva samples, hair samples, appearing in lineups, and providing handwriting exemplars. Rule 16 requires the prosecution to give the defendant and defense counsel reasonable notice of the time and place for when and where the defendant must appear to submit to these procedures. The second category of defense disclosure established by Rule 16 involves expert witnesses, including the results of physical or mental examinations. A defendant is required by Part 5A of Rule 16 to inform the prosecution of any expert witness the defendant intends to call at trial and to permit the prosecutor to inspect any or copy any report or statements of the expert witness. The court is also authorized to order the defendant to disclose the underlying facts or data supporting the expert's opinion, where, in the words of the rule, the interest of justice would be served subject to constitutional limitations, end quote. The court can also require the defendant to direct an expert who has prepared a written report to prepare a written summary of the witness's anticipated testimony. But a defendant has no obligation to disclose an expert and that expert's report or statements if the expert will not testify at trial. The third category relates to the nature of the defense. Part 2C of Rule 16 requires the defendant to disclose the nature of the defense, other than alibi, and to provide the names and addresses of defense witnesses who will be called to trial. The defense disclosure then triggers the prosecution's reciprocal obligation to disclose rebuttal witnesses. The purpose of these requirements is to avoid delaying the trial because of surprise to the prosecution and to provide the prosecution with an adequate opportunity to prepare for trial. But the defendant is not required to inform the prosecution of the defendant's intent not to call witnesses at trial. The fourth category of required disclosure creates special requirements for the defense of alibi. A defendant claiming alibi must provide notice of the location where the defendant claims to have been, together with the names and addresses of the witnesses who will be called at trial to support the alibi defense. The defendant's disclosure then triggers the prosecution's reciprocal obligation to notify the defendant in writing of any witnesses the prosecution will call to rebut the alibi defense. Part 2D of Rule 16 prohibits both the prosecution and the defense from introducing evidence at trial inconsistent with their written disclosures, unless the court finds good cause. And if the defendant fails to properly disclose alibi as defense, the court is required to exclude evidence of alibi unless the court is satisfied that good cause has been shown why the defendant did not comply with the rule. Part 3A of Rule 16 makes clear that defense counsel and the defendant are both under the same constraint as the prosecution not to advise persons having relevant information and material to refrain from discussing the case with opposing counsel or showing opposing counsel any relevant evidence or impeding opposing counsel's investigation. This constraint does not prevent defense counsel, of course, from advising the defendant to remain silent. Like the defendant, the prosecution can move for an order compelling discovery of specific information. But a request for disclosure by the prosecution may be overbroad and therefore invalid if it seeks information that might serve as a link in a chain of evidence tending to establish guilt. And the prosecution's request for disclosure should be denied if it will impermissibly implicate the defendant's constitutional privilege against self-incrimination or deprive the defendant of the constitutional right to effective assistance of counsel. For example, the prosecution has no right to discover written statements of a non-expert witness before the witness testifies at trial. The prosecution's request for discovery should also be denied if it will violate the defense attorney's work product privilege or otherwise deprive the defendant of effective assistance of counsel. While the scope of discovery required of the defendant is limited, where the defendant has an obligation, it is a continuing one, and failure to comply is subject to sanction. Like the prosecution, under Part D of Rule 16, the defendant may seek modification of or release from discovery obligations through a protective order. For the most part, the requirements that Rule 16 imposes on the defendant are self-executing. In the majority of criminal cases, the court does not have to get involved in sorting out a discovery dispute about whether the defendant is required to provide disclosure. But in general, as the possible penalties a defendant is facing increase in severity, the likelihood of a discovery dispute also increases. These disputes will almost always be framed by the defense as implicating the defendant's right against self-incrimination and right to effective assistance of counsel. So, if you are able to anticipate a discovery dispute, be sure to review Rule 16 and try to identify any appellate cases that address similar issues. This way, you'll be better prepared to rule orally from the bench. But if you are unsure about the correct ruling, take the issue under advisement, give yourself some time, and then enter a written ruling or an oral ruling at the next hearing. Thank you.